If he thought the dog was such a threat, why go approach him? The dog was not a threat. Daniel Rodriguez was not a threat, and he wasn't afraid of him. If he'd have been afraid of him, he would have backed off, waited for the partner that he knew was there. But the partner who was there, who did look at his equipment, who did do the spark test, who did have a taser that worked, shot and fired, and it worked. Mr. Rodriguez was taken down, and he went down for the effects of the taser. When the defendant, according to him, Mr. Rodriguez was laying in this position, the defendant went over to him. At that point, the dog was right behind him. This horrible dog that he was so afraid of was right behind him, and he did nothing. That dog was just standing there watching whatever was going on. And this missing Officer Virgil, well, he's the one that actually did the shooting. And his shot was the one that actually took Mr. Rodriguez down. They can tell you that he was outside, down here, hiding in the bushes, as this is the situation that they're telling you. Unless that taser is a laser-guided missile, that is just not true. The lasers don't work that way. Even though Juan Martinez, their expert, wanted you to believe that, it doesn't work that way. Officer Virgil was in the line of sight, and he indicated that this was where he was standing when he fired the taser. And he's the person who actually was able to strike Mr. Rodriguez, who went down. They keep telling you, well, Officer Virgil wasn't there to cover. Officer Virgil wasn't there to help. Who was the only one that was effective with regard to what they were doing? Officer Virgil. The person that they claimed was in the bushes out there. The person who actually was inside at that time. At that point, the defendant, even though he claims that he is concerned about the dog, claims he's concerned about everything that's there, well, he goes down to Daniel Rodriguez. The one thing that he isn't worried about at that point, he isn't worried about the bow that's there in the corner, because he didn't see it, so that can't form part of any of his beliefs. As much as Juan Martinez would like you to believe that those SWAT members can look through walls, he couldn't see anything that was in that bedroom. Couldn't see the shells, couldn't see the rounds, couldn't see anything. And yes, there was some sort of arrow that was sitting there that could have been used with the bow. But again, the defendant didn't see that. So this is just thrown out there for you to consider and think about and say, oh my gosh, what a horrible place. When, number one, the bow and arrow, no indication to show that that was operational. No gun was ever found. So you could just might as well have taken those rounds and thrown them at somebody. They'd been like little pebbles or little rocks that you throw at people. Or the same thing with the shells. Nothing in those rooms indicated there was a weapon involved. And so the defendant can't come in here and as part of the jury instruction say to you, well, I was afraid of the bow and arrow. Can't say he was afraid of the shells or the rounds. He can't say that because he didn't know about them. All he knew is that he wanted to get this person and he went down to get him. And when he went down there, the defendant then says, well, I'm afraid of the dog. All of a sudden, this dog that's been friendly throughout this whole thing, who has done nothing, and who, according to the neighbor, has a reputation, the dog does, for being friendly, wags its back whenever his owner is around, and didn't do anything in this case, all of a sudden, he thinks that that's somehow a threat, because right around this area here, he sees him around there. We know from the neighbor that he wasn't barking, because the neighbor didn't hear it, and those are the ears that are there. The defendant wants you to say, well, her ears probably because she was old, she didn't hear as well as she could have. Well, she heard the gunshots, and when people see something like this going on, they pay attention, and she was paying attention. She didn't hear anything like that. What does the defendant do? He escalates the situation. The dog is in that position, and according to Officer Virgilio, has been in that position throughout. And as the dog is there, the defendant takes his gun and he says, well, shot that dog. Shoots him in the air, and clearly, when the dog was turned away, shoots him in the back. And renders the dog a paraplegic. Even when that bullet went in, and obviously it would have hurt. You didn't hear that dog squeal, you didn't hear that dog bark. But you do know one thing about that dog. He dragged himself with his front feet. the reason that you know that he dragged himself with his front feet is because he'd rendered him a paraplegic. He couldn't use his back feet, and he rubbed himself up against one of the chairs there. And the reason that that's important is if he was really afraid of this dog, the dog's still moving. Why don't you put the coup de grace on him? Why don't you go after him? That dog is still moving. He is not a veterinarian. He does not know when that dog is dead. He does not know that he's rendered him a paraplegic. All he sees is that dog where he went down, moving around with his front feet. And if you really did think that the dog was a threat, why turn your back on him when the dog is still moving? That dog is still moving. He doesn't die instantaneously. It just doesn't happen that way. But the defendant wants you to believe that somehow he's a seer of the future, that somehow he got a medical degree, or somehow he knows that just by nipping a dog in the ear with a bullet or shooting him in the back, he's dead and he's no longer a threat. That can't possibly be. One should have faith in that. The dog is moving around. Just because he shot him now, all of a sudden he's not a threat? He doesn't even know that he hit him. He never even indicated that. So how does he know that the dog is no longer a threat? He was just shooting at the dog. And at that point, he does indicate that Mr. Rodriguez does get up in an apparent effort to save the dog's life. And that's the reason he got up. No other reason. He, in fact, according to the defendant, tried to get in the way of the shot. But the dog, even though he has been shot, is still moving. And if he really wanted to reflect back, and if what he is telling you is actually a true view of events, that dog would have still been a danger to him. But he chose to ignore that because that dog was never a danger. He was in that corner, and in that corner he died. Well, the dog is done, but the violence isn't. And this individual's not done using his handgun. And so he needs an excuse at that point. But somebody begins to intervene. The guy, this other officer, Sergio Virgilio, all of a sudden says, "That's it, I've had enough. I'm going to take over in this situation. I'm going to be the person that takes over this investigation now because now he sees that this dog has been shot. He now knows that Officer Chrisman has this gun in his hand, and he's afraid of him, as he told you. I don't know if Chrisman's going to turn that gun and shoot me." He was there, and he could see what was going on, and you can tell by the actions that you have now been described to you that Richard Chrisman was really somebody at that point that wanted to use his gun. He just wanted to use his gun. And maybe he enjoyed the flavor of shooting that dog. Maybe that's part of what was going on at that point. Didn't need to shoot that dog. Well, Mr. Rodriguez stands up and, according to him, grabs the bicycle. But we know that the bicycle is being backed out of that apartment. We know that Officer Virgilio tells you that I had to stop things at that point. I didn't know if he was going to shoot me, but I started to talk to Mr. Rodriguez. Just started to talk to him. And he responded. And he started to talk to me. And at that point, I was going to walk him out. Richard Chrisman would have none of that. No. He had already, this individual who was started out wanting to be the contact person, wanting to get at it, so quick that he wouldn't even prepare his weapons, so quick that he wouldn't even wait for the other person, the cover person. This individual, that individual, was in there. And now this other officer is taking that away from him, talking to somebody, which is what should have been done in the first place, and it's important for the jury instructions, but begins to wheel the bike out. And as he begins to wheel the bike out, Mr. Rodriguez begins to back away. And he begins to back away from the defendant. Perhaps this distance, if he's standing right there, he does have his hands up. You can say that, well, Officer Virgilio, maybe he's incredible. How about Jeffrey Johnston? He's the medical examiner. He's the person who told you that, yes, there is a nice stippling pattern And whenever a gun fires, there's gunpowder that comes out with the bullet. And the gunpowder may even be faster. And when it comes out, if you're within a certain distance, in this case 3 to 5 feet, you actually get this pattern, according to Dr. Johnson. But maybe you want to believe the defendant instead, because in order for you to believe his story, you would have to believe Dr. Johnston, because there are no voids in this area here. And we know that Dr. Johnston can recognize voids because he tells you, when the hand is here, I did see a void here. So if there weren't going to be any voids, he would see it. If there was anything in front, he would have seen it. If there would have been a panel in front, he would have been able to see it. But he didn't see that. What he saw was just an uninterrupted, if you will, stippling pattern right here where the state believes is the first shot, right in the middle. The defendant says, no, you shouldn't believe Dr. Johnston. Lee Garrett, the person who conducted the test with the defendant's gun and the defendant's .40 caliber ammunition, who did the distance determinations, no, you shouldn't believe him either. You should have faith and believe me. Only believe me. Don't believe these people who have done these tests with my gun and with my rounds. No, they were wrong. You need to believe me. What happens is, shoots right here. And there are a distance away. So that's why no blood comes on the defendant, because the victim is too far away to get the blood on him. It's not that the defendant can walk in between drops of blood. That's not something that they teach in the academy. How to avoid blood. They don't do that. That's not something that can be taught. They don't teach you how to walk around like this so that you miss the blood. What happens is he shoots him. And after he shoots him with his hands up like this, Mr. Rodriguez recoils. Then the defendant shoots him right here. Blood everywhere. The defendant is standing far enough away so that the blood doesn't get on him. The box is to the right, the door is back here, and the defendant moves on. In order to believe the defendant, you have to consider that Dr. Jeffrey Johnson is wrong. You would have to consider that. You would have to believe that he's wrong, this individual who is the head medical examiner here in Maricopa County. You would have to believe that he is wrong. Or you could have faith. You could choose to turn your back on medical science. You could choose to turn your back on forensic science, the art of ballistics. You could turn your back on all that just for the sake of believing the defendant. Just have faith. Follow blindly behind him. That's what he wants you to do. Don't look at this other stuff. Just follow blindly behind him. At that point, we know that the defendant is still him doing these breathing exercises so that he doesn't lose sight of what's going on, settle himself down. He is so in control that he knows it or is cognizant enough that he puts on some gloves. And these gloves have two functions. One function is to protect the wearer from any biological substances that may be there, such as blood. But the other one is it protects the scene so that the individual doesn't leave anything behind. And in this case, the defendant wouldn't leave anything behind because he's got these gloves. He didn't have these gloves on when he did the shooting, so he puts them on afterwards. We also know that the taser has some blood on it, on the sights. So that means one thing and one thing only. That blood didn't come from Richard Chrisman. That blood didn't come from Officer Sergio Virgilio. It didn't come from them. It came from Daniel Rodriguez, which means that that taser was in the vicinity of the blood as it was coming out from Daniel Rodriguez, which again goes against his statement that Officer Virgilio was never near it. Now you got it. Now you got it. See, that's the problem. You didn't get it before. Now you got it. The taser shot itself off alone. See, Officer Virgilio was hiding in the bushes like they told you. But the taser did it itself, and it was close enough so that the blood could get on it. See, that's what you didn't think about. You have to abandon common sense and instead adopt the view that you have to believe what he tells you. How else did the blood get on there? Well, there is one explanation for it. It's a little bit more nefarious, and that would be that the defendant, who had blood on his gloves and was alone, somehow got blood on the gloves. Taser was inside, picked it up. One of the ways that it could have happened. Then he took it outside. We do know from Officer Dominic Barrios that when he got there, we do know that the taser was closer to the breach of the doorway, and the taser was flipped from the pad. The pad, as you're looking at it, was on the left. The taser was on the right. He left. And we do know that Sergio Virgilio just walked away. And so what you have then is a situation where the defendant is there by himself. He's by himself with the body, with the blood. And all of a sudden things turn out with blood. The taser. There's only two ways that could have happened. And they all involve the blood of Daniel Rodriguez, the blood that he spilled. And the answer to it, and said, well, you really want to believe if he was doing his exercises so well, and really thinking about it, and maybe staging the scene, that he picked it up and moved it. You want to believe that? Then that taser was inside, and it was there when Officer Sergio Virgilio fired. He was inside when they fired. Eric Rudy, one of the witnesses that they called, said, I wasn't there during the attack. I don't know anything about it. Dominic Barrios, he came afterwards. Mark Kincannon came afterwards. We also know that the other officers came afterwards. So nobody was there other than the defendant. And that tells you he wants you to believe things that are not there. He wants you to just have faith. Well, let's see what the jury instructions tell us about that faith. What it is that how do you apply what you now know to this case to the jury instructions, which are the law in this case. The first one to discuss is the credibility of witnesses, which is the instruction at the top of page 3. It tells you that when you are evaluating testimony, including the defendants, including Sergio Virgilio, including Maya Hopkins, for example, the woman who didn't write a report, who saw the aphid about 10 feet that way, and who reads somebody else's report, in evaluating that testimony, you should use the tests, the truthfulness that people use in determining matters of importance in everyday life. If a child were to even tell you some of the story, such as this officer told you about seeing Maya Hopkins, about seeing the aphids over there, and you were asking about cookies, even though that's not an everyday important issue, you would say, I really do have issues with you telling me the cookies are there when you know that the cookie jar is in here, and then the cookie jar never moved. But it tells you that in evaluating it, you look at such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in light of the other evidence. You look at all of the other evidence. You consider all of the evidence in light of reason, common sense, and experience. Officer Sergio Virgilio, what motive did he have to come forward and tell what he had just seen, this execution? What absolute motive did he have? None. Nothing at all. In fact, that day, he had lunch with Richard Chrisman. So they obviously were acquaintances. They were on the same unit or squad, whatever they want to call it. They didn't see each other because they would work the same day. There's no motive there for him to come forth and say this because they were obviously acquaintances. No one can say they were friends. I don't think that was brought out. But They were acquaintances. He has no reason to stand up and say this, none whatsoever. And in fact, one of the things that Officer Virgilio is chided for is that when he did get that OC spray in his eyes, which means that he was inside, he's chided for going outside. And one of the effects, or one of the things that can happen with OC spray is that you can't see. You can't breathe, and you can't see. And it would have been a perfect, absolutely perfect opportunity for Sergio Virgilio to say, I didn't see anything. You know? I stepped outside, and I had that pepper spray in my eyes, and I could have seen anything. If you really just wanted to, you're one of the guys, didn't want to cross that blue line, didn't want to have the courage to stand up, he had a built-in crutch. If he didn't want to have the courage, to do the right thing, he had a built-in excuse. Because he could have said, you know what? I had an OC spray in my face, I walked out, and I didn't see anything. He stood up. He did see something. No matter what may have happened to his eyes, he was able to see. He was able to see an injustice. He was able to see a murder, and he stood up to that whole department. One of the other things that we know is that when he was out there, he had a boss, an individual by the name of Sergeant Matson. Sean Matson was his boss. Both of their boss. Stood up to him, too, out there at the scene. You remember Sean Matson, when he took a stand, their witness said, yeah, he was pretty irritated, frustrated, I think. Frustrated was the word that he used. I was frustrated with Virgilio because he wouldn't tell me everything. Sergio Virgilio stood up to him, waited for the detectives to come in, because he did not want this to be swept under the rug. Didn't trust Sean Matson. And what was Sean Matson's response to that? Well, there's somebody sitting next to Sergio Virgilio. And what am I going to do? Rather than call Sergio Virgilio directly on his phone, because as he took a stand and said, he had Sergio Virgilio's cell phone number. He could have called him directly. He didn't want to have that call not answered. So what does he do? He talks to the person standing next to him or sitting with him. And then the phone is handed over. Because he was frustrated. Because he wanted to talk to Sergio Virgilio. He was so frustrated at that scene, he wanted to talk to him. Well, Sergio Virgilio stood up. And he told the story back on that day. And he told the story more than once on that day. He told it once to Kenneth Porter, who was the detective assigned to it, and he told it to Julie Egea, who was a sergeant in the vernacular referred as to the Internal Affairs Department. He told them. And after he told his story, he was interviewed other times by Julie Egea, but after he told the story, and after he went home, some days later, Officer Virgilio was out there on the course, on the golf course, on the driving range, he said, about 7 o'clock in the morning. While he was out there, he got a visit. And he got a visit from Sean Matson, Sergeant Sean Matson, his boss. And he also got a visit along, and someone who came along with Matson was an individual by the name of Sergeant Mark Post. Do you think that they were out there to see whether or not he was actually swinging the club right? Is that what you think they were doing after this killing? No. The reason that they were out there was to return a clipboard. Really? All the way to his house, Matson and Post, both sergeants, are out there talking to Virgilio because they wanted to return his clipboard. Is it a special clipboard? Is it a golden clipboard? Is that what it is? Or is it just an excuse? You know that's what it was. To put pressure on Virgilio to change his mind. It didn't work. He stood up to them too. Then we had the conversation with Julia Egea. He had it there that day, and That's also recorded, and he had other conversations after that with Julia Gio. And those conversations must have been incredibly difficult for Sergio Virgilio, because the person that was in charge, the sergeant, Julia Gio, the person who was asking the questions, who would have written the report or put the report together, was Richard Chrisman's friend. Well, you can't say that. You can say that.
Well,
She was sorry to.
There's no evidence of that. I object, Your Honor.
Ladies and gentlemen, you should rely on your memory and notes of the testimony.
You remember Julia Gio, when she testified that on an occasion she told Richard Chrisman that she was sorry? That's the person that was asking Sergio Virgilio the questions. You can imagine that a person who has bias like that, who says, I'm sorry to the other person, and is questioning the accuser, how fair that questioning is going to be. She was removed from that investigation involving Sergio Virgilio, involving this shooting as the internal affairs case agent. She was actually removed from it. Could not participate any longer. And one of the things that we know with regard to Sean Madsen, for example, as he told you, he could not, the person who was the union organizer, well, he couldn't even come near Virgilio as a result of what he had done. And in Gia, well, she was sorry, said sorry to Richard Chrisman. She was no longer on the case and was removed from the case. Sergio Virgilio stood up, had the courage to do that in the face of these kinds of things, and in the face of these people confronting him. Wasn't clearly easy for him based on that. That's something that your common sense will tell you. And then he came in and told his story again. And he told that story to you. And he was always consistent in regard to the issue of the defendant placing the gun to Daniel Rodriguez's head. And he was always consistent with the shooting of Daniel Rodriguez with his hands up. And when you look at it, one of the things that the jury instruction tells you is that, is what he told you consistent with other evidence? Well, in terms of the putting the gun to the head of Daniel Rodriguez, what else is there that corroborates it? The defendant says he took the gun out. So we know the gun is out immediately when he goes into the trailer. Well, we have Jeffrey Johnston, who told you, right here on the left side, there's a bruise. How could Sergio Virgilio have possibly known that the medical examiner was going to find a bruise there? Couldn't have possibly known that. His statement was on the day this happened. The medical examination was days later. He couldn't have possibly known that. That is corroborated. There's also, you can tell in the pictures, if you don't believe Jeffrey Johnston, well, you can take a look at the pictures yourself. But if you want to have faith, you can believe the defendant that he never put the gun there. The problem with that is that somebody else from the Phoenix Police Department testified. Kathleen Stoller. She's the person who worked in the DNA section before retired. And one of the things that she said was that she did find DNA on the muzzle of the gun. Just couldn't draw any conclusions. So, how could Sergio Virgilio have possibly known that there was going to be DNA on the muzzle of that gun? Couldn't have known that unless that's what he saw. One of the things that we also have to keep in mind is that those bullets, when they come out of this defendant's gun, they come out at approximately 2,000 degrees. And it was 2,000 degrees 4 times over. So there was some DNA there. Plenty of DNA such that 4 bullets at 2,000 degrees couldn't obliterate the fact that there was some DNA there. How could Virgilio have possibly made that up? It's corroborated by medical science, and it's corroborated by DNA, the gold standard with regard to investigations. So yes, he has corroborated what he tells you. He doesn't have other people to come in and tell you that they saw that because there was nobody else there. But he has more than that. He has what is called circumstantial evidence of what he saw. He has his viewing of it, and then he also has the DNA at the muzzle of that gun. And yes, even though the defendant gets up there and denies it to you and says, I just sort of put the gun this way because I wanted to scare the dog, Sergio Virgilio, on the other hand, is corroborated by the medical science. The other thing is with regard to the shooting. Sergio Virgilio told you that Daniel Rodriguez was standing like this, with his hands up, no shirt on, in his bare chest, standing like this. The defendant raised his gun. And then Daniel said, hey, hey, hey. It wasn't an expression of profanity. It wasn't an expression of don't shoot me. No. It was just the kind of expression that someone in that position would do. When somebody is drowning, they scream. They don't start describing the water. In this case, it's hey, hey, hey. And the defendant raised his gun and he shot him right point blank in the chest. We know that that happened and that there was no intervening medium, where there was nothing in between, because Lee Garrett, because of the forensics, will tell you there was a pattern there. And that was an uninterrupted pattern without shadows, without voids. There was nothing in between. How could Sergio Virgilio have known the science of forensics? He wouldn't have known that back then. He was corroborated by the science. He was further corroborated again by Jeffrey Johnson, who said that, well, there was a void here. And according to Sergio Virgilio, he said, well, and I heard the second shot. The other reason that Sergio Virgilio is corroborated is that Lucian Haig, according to Vincent de Mayo, is the preeminent reconstructionist in the United States, indicated that Mr. Rodriguez was leaning slightly backwards when that shot went in. And although de Mayo says, well, no, you can't really take a look at where it ended, because somehow it might have hit something going through the body, and how could there possibly be any reconstruction when the body was involved? It goes against reconstruction to even make that statement. How did Virgilio know that? How would he know that a reconstructionist would, in a sense, say he's telling the truth? One of the things that the defendant did was that they brought in an individual by the name of Vincent de Mayo. And Vincent de Mayo said that there was this leaning toward the front. That's important, because if he's leaning toward the front and he's got the bicycle over his head like that, that's going to be very difficult. But, as I indicated before, the bicycle is going to go flying. Sergio Virgilio is corroborated. Every time he spoke to these people, he told them the same thing. I was afraid. I was afraid Chrisman was going to shoot Daniel, was going to shoot me. Never wavered from that. Never wavered from the fact that he said he saw the defendant place that gun at Daniel Rodriguez's temple, right here. And that's what he did. And he's corroborated. So that's what's important about that particular section, and why when you go back, you evaluate everybody using that section. You don't just use it with regard to Sergio Virgilio. And police officers are not entitled to any more weight than any other witness. That's what the jury instructions tell you. So, for example, with regard to Maya Hawkins, one of the things that you need to consider with regard to her is that she was hugging the defendant's wife, or touching the defendant's wife, before she took the stand. There's a bias there. She likes her. They're friends. Additionally, she was in the courtroom when Sergio Virgilio was testifying, and made herself available then as a witness after she heard what he had to say. There's just a built-in bias with her and what she tried to say. Eric Rudy was somebody that also came in. He had apparently a good relationship with the defendant, such that lent him his flashlight and was concerned. But there's a problem with what these two individuals have to say. And it's a bit concerning. And that's one way of saying it. Because if we take a look at the jury instructions, they tell you how to deal or talk about this particular issue. It indicates that if you find that state has lost, destroyed, or failed to preserve evidence whose contents or quality are important to the issues in this case, and that the explanation for the loss, destruction, or failure to preserve is inadequate, that's at page 9, then you may assume that the evidence was unfavorable to the state. This fact may create a reasonable doubt about the defendant's guilt. That's a problematic jury instruction for the defendant's position. And the reason that that's a problematic jury instruction for the defendant's position is that it is partially based on this issue of the aphids, A-F-I-D-S, the graffiti, the confetti that comes out of the end of the taser. The problem that you have here is that, according to Maya Hawkins, that confetti was back there, 4 or 6 feet away from the door. And everybody agrees, even their expert agrees, even though he says there may have been wind that blew it this way and that way inside the trailer, everybody agrees that the confetti follows the problem. And it doesn't go backwards, it doesn't go anywhere. And we know that Sergio Virgilio's taser was inside because of the blood, and we also know that the confetti was fired inside of the room. The problem for them, and the problem for this jury instruction, is that in their effort, in the defendant's effort to raise this doubt for you, maybe he presented something to you that wasn't quite right. As you sit here, any of you believe almost anything Maya Hawkins has to say? She doesn't have a report that indicates that she ever saw those aphids to start with. She's an individual that relied on somebody else's report to refresh her recollection as to where things were. And even then, she can't get the location correctly. Additionally, she's friends with the defendant. She was here watching everything go on while Sergio Virgilio testified. She was biased. And she puts the aphids in a situation back here, near the bushes, way back here. The door's over there. Remember that? Possible. There's just no way that the aphids could be here. That's problematic, not only for credibility of witnesses purposes, that's also problematic for deception purposes. Why didn't she write it down? Why didn't she wait till now to talk about it? After Sergio Virgilio testified, after she saw the strength of Sergio Virgilio's testimony, why come forward then? Why not write the report then? Oh, well, she said, I told Officer Rudy about it, and I thought he was going to put it in his report. And then I came forward, he called me, and I discussed this issue with the defense attorney. That's problematic. That really is. So when they bring this forward for you to say we didn't seize the aphids, it may not have existed to start with. Look at the person who's saying the aphids are there. It's a physical impossibility to shoot a taser in this direction and strike the person and then have the aphids go 6, 8, 10 feet into the bushes. It just doesn't work that way. But you gotta have faith, right? And then you have Eric Rudy, who says, well, yeah, I was there too. But you know, I saw the aphids too. I absolutely saw the aphids too. But I didn't quite see them in that place, and I was there first, and you know, I was one of the first on the scene, but I didn't see the aphids there. I saw them a little bit closer this way. But still, way out there. Again, ignoring the fact that the shot was that way. It's impossible for the aphids to be here. And the other thing is, you know, I didn't think enough of it to write it down. Didn't think enough of it to note it. But my report, even though it doesn't say anything about it, was used to refresh somebody else's recollection. How can a report that doesn't include the mention of aphids be used to refresh Maya Hawkins' recollection about aphids when it isn't even mentioned? There is a problem there of trying too hard. It can't be anything else other than deception on their part. That's all there is. Because it's impossible, given the technology. It wasn't the wind that was blowing at the time. The storm hadn't hit. They were there immediately after the shooting. They were there immediately after Chrisman killed this individual, Daniel Rodriguez. It wasn't like there was this wind that was blowing or anything that they could say that. No, they can't say that. But they do see the aphids according to them over there. The other person that testified about the aphids, but again, it's creating this problem for them in their haste to present this to you about the aphids because they want to create this issue. How important is it? Doesn't everybody agree that there were 2 tasers that were fired? One that was working by Officer Virgilio, the conscientious officer, and the other one that was fired by the defendant was not so conscientious in his upkeep of that? There's no... what difference does it make when the aphids land? It's just an issue that's being created. But they called Julie Agia, the person who was removed as case agent as part of the internal affairs investigation. And what does she do? Well, according to her, the aphids are here. Can't seem to quite get it right, can they? Where are the aphids? If Sergio Virgilio was going to use his taser from this position and shoot at Daniel Rodriguez, problem. They have a problem. Called the wall. Won't go through it. They won't do it. He could have shot it here. And remember, it wasn't the wind that was blowing. It wasn't anything that was going on. He's the one that was struck. And they're having problems. And this jury instruction addresses that problem. That perhaps there's this issue of that going on. Eric Rudy has a further problem than that. Because if you remember, one of the things that Dominic Barrios told you was that when I got there, Mark Kincannon was inside with the defendant, Richard Chrisman. The person that was standing outside, the person that they wanted everybody to identify, Eric Rudy, was standing guard. Secured the scene. Make sure nothing gets moved. Make sure nothing goes in and out. Make sure everything is pristine. In other words, you're the one that's preserving the scene so that when Kenneth Porter comes by or anybody else comes by, you're going to take a look and say, aha, everything is the same because I stood by. There's a problem with that. Because if you remember Dominic Barrios, when he said to you that right here to the left, where my foot is approximately, was the tablet. And to the right, near the breech, was the taser. And inside was Richard Chrisman, and inside was Mark Kincannon. And they were clearing the trailer. And remember, by this point, Richard Chrisman already has these gloves on. Already has the blood on these gloves. Now has the flashlight, it's clearing it. And they both leave. And the only person that's left behind is Eric Rudy, the guy that saw the aphids over there. There's a problem. Now, the items are moved back. Not only are they moved back, they're switched around. And if you talk about this big wind coming and maybe moving these things, how about the blue gloves that Richard Chrisman left behind? They're still sitting on that chair. If it was such a strong wind that came blowing through there, how come those gloves are still there? It wasn't the wind that moved that. Somebody moved those. Somebody moved those. Someone who was favoring Richard Chrisman talking about aphids. Eric Rudy was the only one that was there. And so that creates problems for them when you are applying this jury instruction about lost, destroyed, or failure to preserve. This movement here, the failure to preserve the position, is solely on Eric Rudy's shoulders. The guy who talked about the aphids, solely on his shoulders. And they're saying, well, if the state, i.e. the Phoenix Police Department, that's who they're talking about, if the Phoenix Police Department failed to preserve, this is the individual who's giving favorable statements, Eric Rudy. If his friend failed to preserve the evidence, then let's give him a benefit. That seem fair to you? Does it seem fair to you that someone who is removed from a case like Julia Gia and then turn around and come in here and make the statement about the etiquettes and then say, well, you know, let's turn around and give him a benefit because we got his friends who were supposed to be watching this, not watch it, and then turn it around and impute it to the state. There is a definite problem with that jury instruction and the conduct of those officers. But it does say if you find that the state has lost, destroyed, or failed to preserve. Did Eric Rudy move that? Probably. Sure he did. Because he's the only one that had access to it. There can be no other way about it. That's what circumstantial evidence is. And circumstantial evidence, just so that we understand what it is given the same weight as direct evidence. I'll read it for you. Evidence may be direct or circumstantial. That's on page 2. Direct evidence is the testimony of a witness who saw, heard, or otherwise observed an event. Circumstantial evidence is proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial evidence. So with regard to the Eric Rudy situation, he is the person that is there guarding these items that were the tablets to the left, the tasers to the right, and they're close to the breach of the door. Imagine, if you will, by way of example, you were at a beach. Doesn't matter what beach it is, but the one important factor about it is that you're standing there by yourself. And water's coming up to your toes. The tide comes up to your toes. While you're standing there, somebody from your left comes by. Woman, man, doesn't matter. They walk by to your right. From your left, your right, see human footprints, and away they go. A minute later, somebody comes to you and says, was there anybody on the beach? You're going to say, sure, one person. How do you know? By direct evidence. Saw, maybe you've heard them as they sloshed on by. That's direct evidence. Compare that to circumstantial evidence and how that applies to Eric Rudy. You're on the same beach, same circumstances, the water's coming up to your toes. You don't see anything to your left, you don't see anything to your right, you don't see anything in front of you. Other than sand, pristine sand. You decide that it's a good time to close your eyes, and you have a towel here. So you lay back down on that towel, you have your wayfarers on, your sunglasses, and you lay there. You don't see, and you don't hear anybody. But as you lay there, you look to your left, you don't see anybody. You look to your right, you don't see anybody. You don't see anything. But a minute or so, after you closed your eyes for a minute, somebody comes by and says to you, has anybody been on this beach? You look down, and although you didn't hear and you didn't see anything, you see they said human footprints walking this way hadn't been there before. You can say somebody was here even though you didn't see it, even though you didn't hear it, because of a set of facts that you have. And the same applies here with regard to circumstantial evidence in Eric Rudy. You have Officer Dominic Barrios saying, yes, I saw that taser, and yes, it had some blood on it. I also saw that taser next to a tablet, and that tablet was on the left, the taser was on the right, they were near the breach. Then later, and the only person that they just beat the drum about, they showed you close-ups over and over about who that person was that was guarding. Do you remember all those photographs, how they showed Detective Porter, bring that in, who is that guy? And then they have other people come in, who is that guy? And then finally that guy came in and said, yeah, that's me, Eric Rudy. I was the only person that was out there. What? After he was out there, and after Dominic Barrios was out there, and at that time, according to Eric Rudy, Richard Chrisman had already left. Items were moved. Eric Rudy moved those items. He failed to preserve. It wasn't Detective Porter, it was the defendant's friend. That's so. Is that something that is going to play in your mind and you're going to say, well, prosecution, that's something that they should have preserved. that's something that really, you think the defense should be given a double bonus for that? Just because his friend did that for him, did them that favor, and because we have somebody by the name of Myra Hawkins who wants to do him a favor to talk about something like that? Are you going to give him the double bonus? No, that's not how it works. But, so therefore, we don't even have to explain the loss, destruction, or failure to preserve. Because it was, if you will, his friends that did it. Well, it says here that the evidence must be of such quality that is important to the issues of the case. What does the confetti tell you? What could the confetti tell you that you don't already know? Well, you know that the taser already has blood. So you know that the firing was either inside or there was some contact with the defendant's gloves who had blood on it, and he touched the taser. So we know that there was only 2 tasers. So we do know that the defendant had one of them in his holster, so we know that. We know that we don't know if there were any aphids that were fired because his taser, we don't know if it was working appropriately. Let's assume that it was, and it was confetti that was fired. Would that tell us anything? How important is that in this case in light of the medical evidence, in light of the forensic evidence, in light of the fact that you have officers trying to change the scene for him? Well, it's not very important at all in light of all of that evidence that you have. Well, how about Virgilio? How about Officer Virgilio and his taser and the confetti that may come from his? Well, we know, because it may be that they want to talk about positioning. Well, we know that the taser was here in the breach, which is where Officer Virgilio said he was. He was at the doorway. If anything, that corroborates what Officer Virgilio was saying, because Dominic Barr will say that's where the taser was. And we know the taser was in contact with Daniel Rodriguez's blood. Do you remember the DNA test that came forward? There was a mixture, and a major component was Daniel Rodriguez. It was his blood that was on that taser. We can talk all about hands going on the taser, but there was blood on that taser, and that's what the DNA results showed. And so you have the taser right here. Does it tell you anything? If you have the taser here and there's an acknowledgement that Daniel Rodriguez was stuck, is there any, by that taser, is there anything that it adds? Does it add anything important to it? It doesn't, because the taser's right here. We already know where it was fired from. It doesn't add anything important to this inquiry. As you consider that jury instruction, have them explain to you. Have them explain to you how it is that they want to give this double benefit to the defendant. Now, while you're thinking about that, how did that prong get out there? How did item number one get way out there where Myra Hawkins said the aphids were? How did that get out there? We know that the tasing happened in here, right? You know that there's the door right there. Do you think that somehow, and again, it's this magical prong that when Mr. Rodriguez took it off, one went like this, and then straight like this, and then it went this way, and then it ended up there. Do you think that's what happened there? And in light of what you have seen about things being moved by Eric Rudy, in light of the fact that the defendant was wearing gloves, and in light of the fact of what Myra Hawkins is telling you and Julia Gia, how do you think that got out there? Daniel Rodriguez didn't put it out there. He didn't. Sergio Virgilio didn't put it out there. Staged scene for you. So that you can sit back there and say, wow, Officer Virgilio really wasn't a good cover officer. Just like Richard Chrisman is saying. See, he was outside all the time. That ignores the fact that the prong went this way, and that it actually struck, by their own admission, by Richard Chrisman's own admission, he went down and felt the effects. Yes, he pulled it out. If he pulled it out, it was inside the scene. And the only person that was inside that scene with any gloves, Richard Chrisman. Mark Kincannon was clearing the trailer. Eric Rudy may or may not have even gone in there, according to him. Julia Gia never went in there. Sergio Virgilio left. Dominic Barry never went in it. And by the time Kenneth Porter got there, that was already out there. Again, there is a staging of the scene. And they're asking now, well, let's give us an extra benefit because we were creative in this particular case. And don't believe Sergio Virgilio, officer who had the courage to stand up. Don't believe him, because we're going to make sure that you don't believe him. We'll send Sergeant Sean Matson to talk to him along with Mark Post. We will then have Julia Gia interview him. Consider that when you're talking about this particular jury instruction. So, what are the crimes here? What is it? Well, you know what he did in a general sense. What he did is wreak havoc, he killed an individual, he scared that individual prior to killing him, and then shot Junior in the back. That's what he did, Junior the dog. Page 5, it tells you that the defendant is charged with second-degree murder. And there's two ways that the defendant committed this crime. He, without premeditation, intentionally caused the death of another person. He, by his own admission, at that point, remember he said it was reflexive, became a killing machine. So there was no premeditation. That's not what we're saying. But did he intentionally do it? Sure he did. In center mass, according to him, just like he had been taught to do. And he went center mass after he had done his yoga exercises. After, according to him, a question from one of you prompted him to say, well, yeah, you know, I had this premonition, but even though I was involved in all this, I had time to breathe in and breathe out. That was somebody who's thinking and who intentionally caused the death of another person. No doubt about it. The defendant intentionally caused the death of Daniel Rodriguez. Doesn't matter that Daniel Rodriguez was using methamphetamine. That's not part of the equation here. And it doesn't matter that he used it 16 hours before. You don't see the methamphetamine being an issue there. It doesn't have anything to do with that. He did it. And then, or a different way that he could have committed this crime, the law provides two different ways, and it's in the disjunctive. It means or. It could be number one, or it can be number two. In this case, it's both. But it's not in the conjunctive, which means there isn't an and there. Once you find, for example, that he intentionally did it, then he intentionally did it. That's it. Or, however, the defendant without premeditation, knowing that his conduct would cause death or serious physical injury, caused the death of another person. Well, did he know that if he shot center mass, there would be serious physical injury causing death? Well, Lon Bartel told you that that's what he's trained to do. Their own witness said, yes, absolutely. That's what we train them to do. And that's exactly what they should do. And so if that's the case, he's met the criteria under both of them. So you do have the second-degree murder. But let's talk about the aggravated assault charge, and then we'll talk about the cruelty to the animals, and then we'll talk about this so-called defense that we have here. Aggravated assault requires two things. That's why everyone's so careful out there. You don't point the guns that you know are not loaded in your direction, because you know that things happen. People get scared. In this case, his gun was loaded. In this case, this individual has just walked in, gun is out. Even if he hadn't pointed it at his head, that's reasonable apprehension. According to him, I just showed it to him. Even though it was for the dog's benefit, I just kind of showed it to him. He did the swipe. Remember he told us to do that? Doesn't require that it be pointed right at him. he admitted that that's what he did. But he went further. He actually touched him. And when he touched him on the left temple, you can imagine the absolute terror. That is absolute apprehension to the nth degree. It's the definition. If you look it up, that's probably what you'll see. And you have the injury that corroborates it. So there is reasonable apprehension. And did he use a handgun? Of course. He admitted that he did. Well, how about the animal? How about Junior? The crime of cruelty to animals requires that the state prove that the defendant intentionally or knowingly, well, he did it intentionally, killed a dog. Did it intentionally. And this dog is in the care and custody of another. Yes, it was. It was in the custody of Daniel Rodriguez. And he did it without legal privilege or consent of the owner. By his own definition, the owner was getting in the way. So it's in the disjunctive, without legal privilege or consent of the owner. It's not in the conjunctive. In other words, you don't have to meet the legal privilege. But did he have a legal privilege to kill him? No, he didn't. It doesn't work for the SPCA. That's what legal privilege talks about. When they say legal privilege, it's when you find a dog that's been hurt on the side of the road and you call the Society for the Prevention of Cruelty to Animals, or you call the Maricopa County Dog Shelter, and they come out there, they have a legal privilege to euthanize dogs, even though the owner says no. He does not work for them. He works for the Phoenix Police Department. This issue of legal privilege does not even apply. That is not him. And did he also do it without the consent of the owner? Absolutely did it without the consent of the owner, according to him. Well, the crimes are committed. But he sat before him and kind of cried and wanted you to believe all in self-defense. All of this, everything was in self-defense. Well, let's talk about self-defense, because it tells you that this is not a case of self-defense. And I emphasize to each and every one of you that this is the law. Irrespective of how you feel about police, irrespective of how you don't feel about police, irrespective of how you feel about the law, whether you agree with it, whether you don't agree with it, your duty is to follow the law. You have no discretion. That was one of the things that was asked of you during the jury selection process, whether or not you would be able to follow the law. Well, it says a police officer is justified in threatening or using physical force. We're now talking about the first incident, the aggravated assault, when the defendant walks in. That's what this applies to. A police officer is justified in threatening or using physical force, the gun, against another, Daniel Rodriguez, if in making or attempting to make an arrest or detention, that's what they said they were doing. They said not arrest, but it's a detention, or in preventing or attempting to prevent an escape. He wasn't in custody, so they weren't attempting to prevent an escape. Such police officer, Richard Chrisman, uses or threatens to use physical force, and all of the following exists. It says all of the following exist. It doesn't say one, it doesn't say two, it doesn't say three, it says all of them exist. And number one, a reasonable person, not Richard Chrisman, a reasonable person, not a reasonable police officer, a reasonable person, someone with common sense, someone who sits in a jury and looks at day-to-day living. It says a reasonable person would believe, that reasonable person would believe that such force, getting the gun out, is immediately necessary to effect the arrest and detention or prevent the escape. By definition, by his own admission from the witness stand, this doesn't apply. Because remember, he said the reason he got the gun out was not to effect the arrest or detention or prevent the escape, because he was still, at this point, remember, walking in. He hadn't made any decisions. There wasn't anything going on. Remember, he said that he was doing it for the purposes of scaring the dog. Well, if he wasn't doing it to effect an arrest or detention or prevent an escape, that first element is not met. And there is no self-defense. in that case involving the aggravated assault. The other issue for him, is it immediately necessary? Is it immediately necessary that he put this gun to Daniel Rodriguez's head? Not according to their expert, Ron Bartel. The way it works is you first try this verbal judo stuff. You talk to the person first. Then you may use, for example, hands-on. That's how it works. That's the staircase, if you will, to deadly violence. Then after that, you may use OC spray, a taser, and then and only then, to effect that detention and arrest, do you use that. He did not stop at verbal, did not do the OC spray, did not do the hands-on, and did not do the taser. He went immediately to deadly force. But is it immediately necessary that he do that? No, not at all. Wasn't immediately necessary to the officer. And remember, it's a reasonable person. Does a reasonable person believe that such force is immediately necessary? You walk in the door and you immediately need to put a gun to somebody's head. It is if you're Richard Chrisman. It is if you've had a conversation with his mother and you've told her, you really can't understand what she's saying. And that just goes to his attitude that day. No one's saying anything else other than that's his attitude. And then you take off and leave your partner behind because you can't wait to get in there, even though you've left your cartridge behind for your taser, even though you didn't even take your taser, much less bring it fully equipped. And so, that's what this individual did. He wanted to get in there. Is it immediately necessary to effect the arrest or detention or prevent the escape? No. It isn't. Not at that point. So there is no justification. There is no self-defense with regard to that. Well, is there self-defense that involves the dog? Let's see. According to him now, self-defense is because the dog, according to him, this dog that's far away is coming at him. Is he saying then that the dog is a deadly weapon or dangerous instrument? Because that's the only way you can use deadly force. But if you look at the crime involving the dog, it says that the crime of cruelty to animals requires the state to prove that the defendant intentionally or knowingly killed a dog in the care and custody of another and without legal privilege or consent of the owner. Well, he's saying it's self-defense. He's saying the dog was coming at him. But it doesn't have anything to do with detention. It doesn't have anything to do with arrest. And it doesn't have anything to do with preventing arrest. So this section does not apply to the dog. Because at that point, that's not what he's talking about. Well, let's go over to the one that involves the use of deadly force on the individual. Let's talk about the one that he believes justifies the use of deadly force against another. The one where he took the gun and shot him. That's at the top of page 8. And a police officer may use deadly force against another only when the peace officer reasonably believes that it is necessary. And it says, you must measure his belief against what a reasonable police officer would have believed. And a reasonable police officer in this case is Sergio Virgilio. Did Sergio Virgilio believe that it was necessary to shoot him? To shoot somebody as they're walking a bicycle out? No. He doesn't get to dictate everything. The jury instructions tell you that you must measure his belief against what a reasonable police officer would have believed. In this case, the difference between this case and many others is you have another police officer whose reasonableness has been presented to you, who was in the same situation as the defendant, who was walking in the defendant's shoes in that trailer. That's a reasonable officer. That officer who began to talk to this individual, Daniel Rodriguez, and Daniel Rodriguez began to comply. And so, you don't take his word for it, even though he wants you to just have belief in what he says. You don't take his word for it. There's another officer, a reasonable officer who's there, who says, no, that wasn't reasonable. And so, this is not a justified killing. But we can look at it further, and it tells you that it's available to defend himself or a third person from what the officer reasonably believes to be the use or imminent use of deadly physical force, or to effect an arrest or detention of a person who the peace officer reasonably believes, and then there's 3 modifiers, has committed, attempted to commit, is attempting to commit a felony involving the use or threatened use of a deadly weapon or dangerous instrument. B, is attempting to escape by the use of a deadly weapon or dangerous instrument. And the past or present conduct of the person, which is known by the peace officer, that the person is likely to endanger human life or inflict serious bodily injury to another person unless apprehended without delay. Well, this requires, under 2, that the individual, Daniel Rodriguez, have with him a deadly weapon or dangerous instrument. All 3 of them indicate that. Daniel Rodriguez did not have a gun, so he doesn't have a deadly weapon. They're going to say to you, well, it's a dangerous instrument, that bicycle, don't you know? All those people that are in the Tour de France, potential murderers, I'll have you know. That's what they want you to believe. Everybody in the Tour de France, look out for them. You've seen them as they run, other people run by them, and then the bikes are coming at them. That's 40, 50, 60 miles an hour. Those people, well, they haven't. Those people are just looking for a murder charge. Well, what is a dangerous instrument? It tells you. A dangerous instrument means anything that is readily capable. Well, a knife is readily capable to cause injury. A fork maybe, a screwdriver, a box cutter, a sledgehammer. Those are readily capable of causing death or serious physical injury under the circumstances. For example, you just don't see somebody with a knife while they're eating a steak and say, oh, that's a dangerous instrument. No, they're using it to cut their steak or they're using it to cut their chicken. So it's under circumstances in which it's used, attempted to be used, or threatened to be used. Well, what about this case? Indicates to them this bicycle is a dangerous instrument. One of the things that you first have to look at is the item itself. Kind of bulky. You're going to have it back there. And it's kind of not very maneuverable. The way to move it from one place to the other is to roll it. If you roll a bicycle from one place to the other, it's not going to cause too much harm because, as we see with the Tour de France, that's what it's meant to do. And that's what was happening in this case. What else about it? Well, it does have pedals, but those pedals come at you at an angle so that you don't really know what's there. Whether or not those are coming at you or not. You do have handlebars on it, but again, they're not pointing like a knife or anything like that that's going to come at you. They're not like that at all. So, is that readily capable? Is that something that is readily capable to cause death or serious physical injury? No. How about just something about the wheels turning? No. In fact, that has nothing to do with indicating that this is a dangerous instrument. This is the state's position that a bicycle is not a dangerous instrument because it is not readily, the phrase is readily capable. How many people have had their bikes fall on them? Many people. Did they die from that? If there were a motorcycle, you would have a different argument. But a bicycle? How many people crash when they're out there on their events? Lots of people. None of those is indicated. None of those events are readily capable of causing death or serious physical injury. So you have this bicycle, and he's telling you, well, the way it's being used, that's the key here. He has to, of course, because you have to believe, because of the medical evidence, he has to have the bicycle standing up this way. And the bicycle, at least at the seat level, is approximately 3 feet. A little bigger, 3 feet. And it's a little bit higher at the handlebar. And one of the things that happens when you lift those is that they're kind of hard to grab because once you do that, the front tire or the handlebars turn, kind of clumsy to grab that way. the way that he's describing it. But he has to have the hands up like this because of the stippling evidence. He can't have the hands here, he can't have them here. He's got to have the hands up here. And it takes quite a bit of strength to get it all the way up here because the hands have to be up here for it to make sense and for him to have belief. But the problem with that, and something that he forgot, with the truth, as I said before, with regard to the truth, he ain't got nothing to remember. But he has a lot to remember. And one of the things that he forgets is that when he's got the bicycle up here, it's not a bicycle that's all the way through. It's got these wires that come through. It's got a tire. It's got bars that go back and forth. It's got a seat that goes through. And he's got this bicycle right here that doesn't leave him room to explain why we have such a nice stippling pattern here in the chest. It ignores the fact that the stippling pattern is there and it doesn't have any voids. So even if he tells you, number one, it couldn't have happened that way. It couldn't have happened that way because of the stippling pattern. It just couldn't. And that would have required him, without invading anybody's space, to be much closer than 3 to 6 feet. I'm sorry, than 3 to 5 feet. It would have required the gun to be closer, if you will, because there is this intermediary thing that is picking up the stippling in order to get this same pattern. The bicycle would have had to be much, much closer than the way that he describes it. Either way, those particles that are traveling ahead of the bullet, the gunpowder that is traveling ahead of the bullet, that are 2,000 degrees, that are like a dust storm, would have damaged the part that they hit. You can look at the bicycle yourself, and you can see that there is no defect. There are no defects to that thing. There is no bullet shot either. There's no scraping of any paint there. There is no stippling on the bicycle. And, in addition to that, there is no voids, if you will, here in the chest where the shot went through. No way that bicycle could have been up there like that. Believe that it did. He wants you to believe it. The other problem is that, remember, it has to be readily capable of causing death in the way that it is used. Mr. Rodriguez can't just have a bicycle up here. He's got to have it in a position of readily capable, i.e. in action, ready to move forward. And if he's moving forward, even if you shoot somebody, the person goes down, but the motion continues. I'll tell you about the bike falling right, and it never did. It's impossible for the bicycle to have been used in that fashion that he described. The forensic evidence says it wasn't. The medical evidence says it wasn't. And it just makes no sense that this individual could raise it so high and hold it up like this. Like that, just push it that way. But he wants you to have faith. To this faith, there's a standard. And this standard is beyond a reasonable doubt. And that tells you that in this case, standard is beyond a reasonable doubt. And proof beyond a reasonable doubt. Everybody has heard it. There's proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. In criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced of the defendant's guilt of any of the crimes charged, you must find him guilty. What this tells you is that it doesn't have to be a perfect case. In other words, the state does not have to prove this to you with absolute certainty. The law does not require proof that overcomes every doubt. It's just beyond a reasonable doubt. And that's the standard that is applied in this particular case. Is there any doubt that he's the person that shot Daniel Rodriguez and killed him? No. Did he do it intentionally? Of course he did. Did he do it with premeditation? Yes, the state concedes that. The aggravated assault, beyond a reasonable doubt that he's the person that had the gun in his hand? Absolutely. Beyond any doubt whatsoever that if an individual comes near you, and again, I don't want to invade anybody's space, and they come at you very quickly with a gun, any doubt that would cause you some apprehension or cause apprehension? Absolutely. And did he do it with a gun? Yes. And do you have the corroboration? Yes, you do. He did do that. Beyond a reasonable doubt. And beyond a reasonable doubt, he shot the dog. There's no reason to shoot the dog. No reason to shoot it. The dog was far away. So against that, beyond a reasonable doubt, has he been able to show you that he's justified in using this particular form of deadly force? No. He made it up. He made it up with regard to the bicycle because the forensic evidence does not support what he told you. He tried to get help from his friends who were moving things around and they were talking about aphids, but it doesn't change the fact that he did not. It could not have happened the way that he said. Forensically speaking, or medically speaking. You take a break now. You have a break, or do you want me to take it?
I don't know. Are you close to finishing?
No, I got maybe 25 minutes. 30 minutes. I'll go ahead if you want me to.
No. You answered my question. Ladies and gentlemen, we'll take the afternoon break at this time. Please remember the admonition, keep an open mind. Don't discuss the case. Be at 3:07. Jurors are excused. It's 3:08.
What?